Jennings Strauss Labor and Employment Department Fall Webinar. I'm John Belitis, I chair the department, and I have with me today my colleagues Otto Schill, Dan Peabody, and Julia Akin, who are going to present the material for us today. I'm not going to spend a lot of time on introductory remarks. We've got a lot of things to cover, and we want to do our best to finish around noon. If you do have questions during the course of the webinar, just use the chat feature in Zoom. We're monitoring that. We'll do our best to get to your questions given our time constraints, keeping that in mind. So if we don't get to a question that you have, as always, feel free to reach out to any of us after the webinar. We are always happy to chat with any of you about the material that we're going to present today. Now, if you want CLE credit for the presentation today, you can do that one of two ways. You can either use the chat feature again in Zoom, just make sure you include your full name and the request for CLE credit, or you can email Teresi, our marketing director. Her email address was in the email that you received with the link today for the webinar. So we've got 3 topics to cover today, and we're going to spend about 15 minutes on each one and hope to wrap up in about an hour. And the topics are the Biden administration vaccine mandate, an update on that, restrictive covenants, and LGBTQ rights in the workplace. So let's get right into it and talk a little bit about an update on the Biden vaccine enforcement measures and the Emergency Temporary Standard, or ETS, that we've all been waiting for to shed light on those measures. Now, you all may remember back in early September that President Biden held a press conference in which he announced that he was going to impose, with the help of other federal agencies, a vaccine mandate that would cover federal contractors, federal employees, and in concept, businesses, private sector businesses with 100 or more workers. Now, we've known for a while about some of the details relating to federal employees and federal contractors as they relate to the mandate. But what we haven't seen or heard about are those details relating to private sector businesses. And that's because the president decided that he would task the Occupational Safety and Health Administration with drafting the ETS, the rule that would implement the mandate. And we have known for a couple of weeks now that OSHA delivered a draft of that ETS to the White House. And ever since then, we've been told it'll be open to the public, it'll be published any day now, any day now. Well, coincidentally, any day now happens to be today, because this morning, just this morning, OSHA published multiple ETSs which explain how the vaccine mandate's going to work for private sector businesses. It only consisted of about 500 pages of material. And so we've been scrambling around, reading it, trying to figure out how we best can summarize it for you this morning. And so without delaying any further, I'm going to turn this over to Otto to update you on this extremely timely and very important issue. Otto, go ahead.
Thanks, John. Well, it was interesting this morning. I got up early to tune up the slides on this, and as I was sitting there at 7 o'clock Washington time, 4 o'clock Arizona time, it rolled around to about 7:30 or 8, and the standard had hit. So this is as up to date as you can get. So as of 8 this morning, we have, oops, there's us. We have 3 pieces of guidance about vaccine mandates. We have the Emergency Temporary Standard for healthcare workers that was implemented back in July. We have the mandates for covered contract employees of federal contractors, and also for the federal employee workforce that was, as John said, issued pursuant to the President's executive order on September 9th, and then was embodied in a special rule by the Safety Task Force. And then we have another emergency temporary standard from OSHA issued just this morning with respect to employers employing 100 or more employees. So we're going to talk about each of those. We'll talk a little bit about employees may want to object, because in each of those cases, the federal government put on the employers the burden to deal with employees who don't want to be vaccinated. There are two valid ways for that, those objections to stop a vaccination mandate. One is with a sincerely held religious belief or objection. The other is with respect to a disability, which generally includes a medical condition. And so we'll talk a little bit about those. And then you may or may not know that attorneys general for, I believe it's up to 23 states now, filed lawsuits to stop the vaccination mandates. That largely has to do with the emergency temporary standard issued this morning. So what we saw, as John said, the emergency temporary standard itself is 470 some pages long. Of that, approximately 370 pages are dedicated to legal argument designed to justify OSHA's adoption of the rule on an emergency basis, and, by the way, its preemption of all state and local laws that are inconsistent with it. And we'll talk a little bit about that problem. And then there was 50 or 70 pages of explanation, and then 20 pages of the actual standard. So that's what we got to do it for this morning. It was more fun than I can tell you. And we want to talk about the basis for some of those legal challenges so that you understand, and then we can talk a little bit about preparation. First of all, understand that some employers have considered whether to have their own vaccination mandates. That's permissible. There's no law that prohibits it, but they can't be discriminatory, and that takes into account the Title VII protected classes as well as the Americans with Disabilities Act. I've included a reference to the EEOC guidance on employer vaccine mandates. I'm not sure that's as important as it was before, but many employers have considered that. Some have started it. Some of the airlines, for example, started. They've had heavy pushback, and so people are kind of bouncing around, and you'll see as we go through, even the vaccine mandates provide certain ways out depending on which mandate you're talking about. The mandate issued today, or the emergency temporary standard issued today, is more flexible than the federal contractors' rules and the standard for healthcare workers. The Occupational Health and Safety Act of 1970 is the statute to which OSHA is looking for its authority to issue these emergency temporary standards. One thing, as you might imagine, that is coming up in some of the cases that have been filed is the fact that we've had COVID for 2 years. President Biden issued executive orders starting in June or so, and in September. It's now November. OSHA's finally issuing something, and some people are asking, what is the emergency? So those are going to be at issue. Typically, the government is required to go through a normal notice and comment publication process of publishing proposed standards, seeking notice and comment, and then finalizing the standards. These emergency temporary standards are being published as proposed, but being enforced as emergency standards under the authority of Section 6C of the Health and Safety Act of 1970. That statute requires that employees have to be exposed to grave danger from exposure to a substance or agent or some new hazard. And the standard has to be necessary to protect employees. Well, you can imagine, in light of the long time over which we've been dealing with COVID and the late stage that we're at, there's more than little politics associated with this, and I think the lawsuits are going to focus on these factors and whether OSHA in fact has met these standards. Particularly, I've seen banter about whether there's a grave danger, whether this represents a substance or agent at all, because it's an illness or a microorganism as opposed to a substance or agent. And then everybody's wondering whether it's really necessary to protect, and there are a lot of people who don't like vaccines. Importantly, as I mentioned before, the emergency temporary standard issued this morning expressly preempts state and local requirements related to vaccine verification of vaccination status, face coverings, and testing requirements, raising the question of whether a federal agency without a statute can preempt state and local law. So that's another issue. We won't spend a lot of time talking about it, but those are issues we expect to see in litigation. Going back in time, it's important to note, and I won't go through these cases in detail, but starting with the Jacobson versus Massachusetts case in 1905, the U.S. Supreme Court has considered whether vaccine mandates are appropriate. In the Jacobson case, which is sort of the seminal case in the area, Massachusetts had imposed by statute a smallpox vaccination requirement because they were having a smallpox outbreak. And I've included the language from the cases, so I won't read it. But essentially, the Supreme Court concluded that where there's a law of general application and it's done to meet an important public safety purpose, that can overcome an individual right not to be vaccinated. And there are various constitutional standards discussed. I believe this one was the due process standard, if I recall correctly. And they concluded that there was no basis for overturning the Massachusetts standard. And then you see the Washington Harper case, which was a case involving the mandatory giving of antipsychotic drugs to inmates who posed a danger, and the public necessity there was found to be more important than the individual's objection. And finally, in Employment Division versus Smith, there was a claim with respect to another a religious objection to another government-mandated health standard, and it was found that standard did not violate the Free Exercise Clause of the Constitution. All of that to say that traditionally, where vaccine mandates have been imposed as a generally applicable rule to address an important public safety concern, that can overcome some individual constitutional rights. Now, in each of those cases, we're talking about state laws, not federal laws, and typically regulation of that kind has been left to the state. So we'll see in coming litigation what the courts do with the idea of a federal mandate, particularly one that's coming fairly late in the game and that has a lot of controversy associated with it. With that, let's review briefly the two emergency temporary standards and then the rule with respect to federal contractors. The emergency temporary standard with respect to healthcare organizations and employees who are working in or supporting healthcare was published in the Federal Register on June 21st, 2021. It was effective July 6th. It is much broader than vaccination. It covers a variety of record-keeping rules, policies that must be adopted, very, very detailed rules to protect employees and presumably patients as well, I think. Employers have to provide under that a reasonable time for employees to be vaccinated, allow them to make appointments, do registration, travel, post-vaccination, and they have to provide paid leave for it. And there can't be any cost to the employees for doing those things. With respect to federal contractors, On September 9th, the President issued the federal executive order listed there, requiring all contract instruments or contract-like instruments to contain a particular paragraph which requires each contract to require the contractor to comply with all federal safety standards from the Safer Federal Workforce Task Force on this issue. So that organization adopted a standard. It is applicable to new contracts or awarded on or after November 14th, 2021. It applies to any extensions or options exercised between October 15th and November 24th, when a contract has been awarded prior to October 15th. For contracts that were awarded prior to October 15th and are not yet continued or extended, then the rule doesn't apply. Compliance failure, as with every other government organization, the task force has created an extensive list of question and answers. Apparently, we've replaced the proper regulatory process with Q&As. So I've listed the website there that you can look at those extensive question and answers. But note, for those of you who are federal contractors, that if there's failure by a contractor to comply, the contracting officer is directed to work towards compliance, but can take measures up to and including contract termination, which is fairly significant. Under the federal contractor standard, employees have to be vaccinated by January 4th. That was December 8th up until this morning, and it's been extended to match the other requirements. Or if later, the first day of performance for a new contract or an extension or renewal of that contract. Again, accommodations have to be considered. That is true under the health emergency standard. It's true under the emergency standard issued today, and it is true for federal contractors as well. So if someone has a medical need or reason that they can't be vaccinated or other disability accommodation, you have to consider that under the normal process. And if they have a sincerely held religious belief, you have to give that consideration. We'll talk about that a little later. Covered employees or covered contract employees must comply with mask and distancing requirements, except when working at home. They don't have to do that at home. That was kind of them. And when they're at a location that's controlled by a covered contractor, other than, well, even including at home, they have to be vaccinated. Any full or part-time employee of the covered contractor working in a workplace in connection with a covered contract or supporting a covered contract is a covered contract employee. So I'll let you look at those definitions in more detail. So let's talk about, and I'll put a little more detail in with respect to the emergency temporary standard issued this morning, because that probably affects most people. It was filed this morning at about 8 o'clock in Washington time. It is effective as of January 8, 2022. It applies to employers with over 100 employees, but you can see the list of people it doesn't apply to. So it is exclusive of the federal workforce, the federal contractors, and the healthcare employees. So the other documents that we've talked about apply to those specific workforces. It does not imply, the new mandate does not apply to employees who do not report to a workplace where other individuals are present. So if someone works exclusively from home, then there can be a pass, again, not for federal contractors, not for healthcare workers, but for everybody else. I think I may as well mention now that I think that could be a problem when employers are having trouble bringing people back to work, and now this is a new impetus for people to work at home. My personal opinion is that may be part of the politics associated with this, because you can see throughout all of these standards echoes of the administration's goals with respect to paid leave and other elements that they're trying to pass in conjunction with other legislation currently being considered. Also, this standard does not apply to people working exclusively outdoors, and there's an extensive discussion about what that means. But suffice it to say that if you go indoors at all, then you don't typically qualify for that exception. But they consider who's in trucks with whom and what transportation looks like, what the workplace looks like, and it's very factually based. Under the emergency temporary standard, employers are required to adopt a written vaccination policy and a policy that allows employees to elect to undergo regular testing and wearing a mask in lieu of vaccination. So this is not strictly speaking a mask mandate, but they have to do one or the other. That's good news, frankly, because there's so many people who are frustrated by vaccination requirements that at least it allows you to keep some calm in the workplace, we think. Again, the reasonable accommodations continue to apply, and those things are important to consider. There can be different policies if you've got different locations and different work groups that work together, so you don't have to have one uniform policy for the entire company. But again, I'm hitting the highlights, and there are pages and pages and pages of detail about all of these things. And then employers now need to look at their current policies and adjust for these new sets of rules. You'll see in particularly that's going to be important with respect to paid leave. Employers need to determine what records are important and maintain records regarding each employee's vaccination status. You can see the list of records that may be acceptable, and employers need to be prepared on a 24-hour notice to provide those records to OSHA for inspection. So these are the obligations of the employers to support the vaccination mandate. They have to provide reasonable time, which is up to 4 hours of paid leave, so that employees can arrange for and be gone to accomplish vaccination if the employer happens not to provide vaccination at their place of business. This paid leave, this 4 hours of paid leave, is in addition to other paid leave. So they also have to, they don't have to provide paid leave for vaccination that occurs outside of work hours, but during work hours, they do have to provide work hours if the employees choose to use those, provide up to 4 hours, and they have to provide a reasonable time and paid sick leave for an employee to recover. So the paid sick leave requirement for recovery can be offset by other paid sick leave that's mandated. So for example, in Arizona, we have a paid sick leave requirement, and that paid sick leave can be used to cover this paid sick leave requirement. But the Arizona paid sick leave that's accrued cannot be used to cover the 4 hours. That's an additional benefit the government's giving to employees to allow for the vaccination. And I think it's probably as an incentive to do that. You don't have to reimburse your employees for transportation going to and from. And remember, there may be other requirements, state, local, some federal laws, and collective bargaining agreements that may provide other kinds of leave that's available. Again, the other kinds of leave can offset the recovery paid leave requirement, not the vaccination 4-hour paid leave requirement. Here are the notification requirements. I'll skip over those, but remember, this is an OSHA standard. There are reporting requirements if somebody's hospitalized or dies as a result of an illness contracted at work. That's a reportable event. Remember, if there's an employee death, that's a 24-hour reporting requirement. No, excuse me, that's wrong. It's less than 24 hours. What is it, Julia, 16? It's either 8 or 16 hours. It is not a 24-hour reporting period. So in the event of an employee death, that's important to consider. And again, records have to be available for inspection. These are the things that employers need to notify their employees about. I'll skip past those because you can read them there. And let's talk for just a moment about the disability and religious accommodation. Actually, I do want to back up. I want to highlight the fact that you do need to make your employees aware of the standard and what your policies are about those. You have to provide the document that's listed there from the CDC, key things to know about COVID-19 vaccines. There are non-retaliation provisions, and you have to make employees aware of those, and you have to make them aware of criminal penalties that exist for false reporting. And then with respect to disability and religious accommodations, if an employer does not have a factual basis for questioning the reason for the accommodation request, then you really have to honor the accommodation request. If you are aware of objective facts that cause you to question, then you can make a limited factual inquiry. But if you're thinking of denying a request for accommodation, it's very important to base your denial on factual circumstances. And I've listed for you there a reference to the EEOC guidance on accommodations so that you can see the frequently asked questions. But if you're going to deny something, basing it on the facts is really important. Julie, I know you've had some discussions about this lately. What have you seen in terms of strange fact patterns?
Yes, well, so far, the most common accommodation requests we're getting that are the most challenging for employers are the religious accommodation requests, because the EEOC has taken a somewhat conservative line on that, in that they've made it clear that if it's a political belief or just a closely held opinion, that is not going to satisfy the standard for a religious accommodation. And so we're getting a lot of religious accommodation requests that are sort of political statements couched in religious terms. So you need to be very careful when you're looking at those if you want to try to, enforce whether or not someone is entitled to an accommodation, and look at, okay, is this vaccine specific? Is there a tenet in this religion or sincerely held belief that this individual purports to have that prohibits that individual from getting a vaccine? And that's a pretty specific standard. So it's not just, well, I have this general religious belief or background, and therefore, I'm against having people tell me I need to make some sort of alteration to my body. That is not sufficient. So you really have to parse out each factual situation and see, is this person saying something that their religion would actually prohibit them from getting this particular vaccine?
Yeah,
Well,
and I would encourage everybody, if you run into an accommodation request that is just borderline, don't hesitate to give us a call. We can help you out and counsel you on it fairly quickly. We've gone through a lot of them over the months, and so we're here to help if you need us. A couple of things, thanks Otto, that was fantastic, that I just wanted to add based on my quick read of the 470 pages this morning. And that is one question that was really concerning to business owners was, in the test alternative scenario, meaning if a worker says, I would rather get tested twice a week than have to get the vaccine, the question that arose after the September press conference was, who's going to bear the cost for the testing? Who's going to pay for it? And as far as I understand from my read this morning, the employers covered by the mandate are not required to pay for testing. So that answers that question. And if I'm wrong about that, I'm sure Otto will correct me, but that's a very significant point. Remember,
I agree with you.
Yeah, remember this starts in the first week in January. So in terms of getting ready for this and ramping up, you've got some time. And if you need some help, just reach out to us and we will help you.
Well, and to emphasize that, at very least, you need to review all your paid sick leave policies and make sure that they're consistent with the new guidance.
Right, very good. Okay, so as I said at the beginning, if you have questions about this, a lot of material that we covered in a very short period of time, don't hesitate to reach out. We will try and we're happy to talk to you about anything we present today. If you just reach out to us, give us a call, send us an email message. The next topic we're going to talk about, restrictive covenants, is something that we've presented on many times over the years. But typically, the presentation that we've offered has been focused on or about how to develop, draft, and implement enforceable restrictive covenants, okay? We are going to sort of continue that discussion today and take it sort of to its next logical step by talking about the scenario in which you have an enforceable restrictive covenant, and then an employee who is covered by the covenant leaves, and then perhaps starts breaching it. And so Dan is going to talk to us about things you should keep in mind in that scenario, assuming you've got good restrictive covenants in place. So Dan, you want to educate us on that?
Ultimately, that's the goal, yes, to educate everybody on that. I'm trying to share my screen right now. Which I should be able to do better than Otto did. Apparently I cannot.
Do you want one of us to share and sort of go through it for you?
Yeah, if you can do that, that'll be fine. That may be more efficient. We want to respect everybody's time. Yeah, if you don't mind doing that and starting on screen slide 17.
You want me to do it?
No, I'll do it so that I can go right after him.
Oh, yeah, that's true.
Oh, that works.
You can tell that you should come to us for legal advice and not technical confusion.
There you go. I figured that all out by myself. No, we have IT like right next to me holding my hand. All right, let me get through this for you.
Awesome. Thank you so much. Like John just said a bit ago, we've talked about restrictive covenants before. What we're going to talk about today is what to do after you have your restrictive covenant and you actually need to use it or enforce it. Julie, if you want to go ahead and play the video here. Oh, we don't have audio.
This is where Daniel and I will do the voices for the characters.
That's exactly it. What's slightly sad is that I probably could. What you can see here from the video is that Michael Scott is starting a competing paper company, and Charles Miner, who is the new corporate manager for Dunder Mifflin, is walking in and telling Michael that he can't ignore the fact that he has learned that Michael is going to be starting a competing paper company. So that's our scenario. If we want to go next. So the scenario that we have is you have a valid enforceable restrictive covenant, maybe a non-solicit, maybe a non-compete. We know that it's valid, we know that it's enforceable. We're going to act as though those are givens for right now. And we know they're valid and enforceable because you either had myself or Julia Akin or Otto or John draft them. So we know they're good to go. The next fact though is that you have an employee that's leaving, and this is either a key employee or somebody that's just subject to the non-solicit or non-compete. And another possible situation is that you have an employee leaving and you know they are going to be competing with you, or you already know that they're soliciting, or there's a high likelihood that they'll be soliciting either current employees or your current customers or clients. We can go to the next slide. So again, we're going to talk about your initial steps, or we're going to be talking about what to do once you have that employee that's leaving and you need to enforce your restrictive covenants. Couple of initial steps. First thing, let counsel know. You don't have to do that initially. You can do that at any point in the process, obviously, but we would prefer if you let us know as soon as possible so that way we can advise you going forward and we can make sure that there's no missteps. Also, we want to be involved early in the process. That doesn't take an active role. That doesn't mean we need to be the ones doing the communications. We can stay behind the curtain, if you will, but we do want to know so that way we can be aware of what's going on. If something does happen, if you do need us to take a more active role, we already have that understanding. We're already there. Beyond letting us know as soon as possible, one very simple step, and this is really a preventative step before anything has really hit the fan, is simply reminding the employee of the obligations. There's absolutely no problem with you notifying the employee or reminding the employee that they have non-solicit, non-compete obligations, for example, providing them with a copy of the agreement that they've signed and letting them know that exists and that it will be enforced. There's absolutely nothing wrong with doing that. And that's a good to take whenever there's an employee that's subject to a non-solicit or non-compete, just reminding them of that, providing them a copy whenever they will be leaving. And we'll go to the next slide. After our initial steps, there's some secondary steps that can be taken. And these steps are designed to, to start preparing, just in case something more does need to occur. Taking these steps will help make sure that we can effectively enforce the restrictive covenants if need be. First and foremost, monitor customer and employee changes. You can usually tell if an employee is, or a former employee or soon to be former employee is soliciting customer clients or current employees based on certain changes. So for example, if the soon to be former employee, all of their customers or clients with whom they have contact are leaving, pretty good indication that they're already letting them know that they're going to be leaving where they're going. Same thing with employees. If you notice a change in the employees with whom that individual works or is close with, that may be an indication that they are soliciting those employees to go with them when they leave. A very important thing that we want to do as much as will preserve employee communications. Now, most of these employee communications are probably going to be preserved via email server, et cetera, but we really want to make sure that we preserve these things. Preserve employee communications. If there's a company phone that the individual has or the soon to be former employee has, their emails, of course, any IM Slack stuff, we want to make sure that we preserve those to the best of our ability, because you would be surprised at how frequently an employee will use an employer's means of communication to solicit either employees or customers or clients. And we want to have that preserved if something does have to happen, if we do need to move for a preliminary injunction or a temporary restraining order, which we'll get to later. We have the ability to present that evidence early, which will help, number one, the merits of the case, and will also help with the cost of such an action. We also want to review the employee's final months of work. And what I mean is take a look at what the employee was doing. If you can see that the employee was, for example, touching an inordinate amount of customer files, that's a pretty good indication that they were preparing to compete or preparing to solicit, and they were going through that to gather information. Same thing with price lists or customer or client contact information. If they are accessing information that they normally wouldn't, or printing information that they normally wouldn't, we want to be able to present that to the former employee, and we also want to be able to present that to the court if need be. This is just, these steps are really just a way to gather the evidence if we need to take an additional step. We'll go to the next slide. So now, we've taken our initial steps. We've contacted the fine labor and employment attorneys at Jennings Strauss. We have notified the employee of their obligation. We've started to monitor customer, client, and employee interactions. We've noticed that the employee is seemingly going to compete or solicit employees or customers or clients. We noticed this because we've been monitoring files and we see that they have been, or that they're taking weird actions. There's a couple of things that we can do at this point. We can resolve this without litigation, or we can potentially litigate this to resolve it. Of course, we want to try and resolve it outside of litigation if at all possible. There's one real way to do that, but a couple of steps that we want to take. Number one, we can inform the new employer or the entity that the employee is going to compete or solicit. I'm a little bit wary of doing this. There's one caveat to doing that, and that is we don't want to interfere with the former employee's new employment relationship. We 100% have the right to enforce our obligations, and we have a right to let the employer know, actually. This is just a touchy area. We don't in any way want to open ourselves up to any liability. So this one, proceed with caution. And certainly at this point, if you do expect that the employee is competing or soliciting, that's definitely when you want to have one of the Jennings Strauss attorneys get involved. For example, if a letter does need to be sent to the new employer, that should be coming from us. Same thing with a demand letter. And at this point, the way the demand letter would look is it would remind the employee again, here's the obligations that you have. At this point, here are the facts that we have gathered that indicate that you plan on violating your obligations. You need to stop. And if you don't stop, we're going to proceed with litigation and we'll pursue all remedies available, including our attorney's fees for this. Then we get to the last step. This is the final step that we could take. If need be, we litigate this. If you have an employee that is competing or soliciting employees in violation of non-compete or non-solicit, we can move for a preliminary injunction or a temporary restraining order. Ultimately, the goal would be to get an order from the court saying, former employee, you need to stop. You have this obligation. You're contractually bound to not compete or not solicit. You must do so. Now, again, a little bit of a caveat there. Preliminary injunctions, temporary restraining orders. We can certainly move for those. We can achieve those. We've done it many a times, but we do want to try and avoid that. But of course, if we have to, we will. That is the last and final step. And with that, I will happily turn it over to Julia.
Well, before we get to Julia, let's just take a moment to just revisit a couple of things. Dan, that was fantastic. And I will add that it's great to start out incrementally with these things, like with a letter, talking to the new employer very cautiously, because these lawsuits are extremely costly for any of you who've been involved in them. They essentially require a small trial at the very beginning of the process, and it front loads a lot of expense. So to the extent you can resolve these in the beginning informally, it's better than going the litigation route. So keep that in mind. We got a couple of really quick questions before we move on to Julia relating to vaccines, and I'm going to answer them really quickly, and then if I get anything wrong, Otto's going to correct me. The first question was, what if a worker doesn't want to get vaccinated or get tested because of a religious belief? We've talked about this, and we can't think of a scenario where a religion is going to prohibit somebody from getting a test. It may prohibit them from taking a vaccine, but I don't think you're going to run into a scenario where someone can legitimately say, my religion doesn't allow me to even get a test. So I would be very wary about that, and I would really look at a accommodation request like that very critically, because I don't think that's going to play out with any legitimacy. The other question was, does the 100 plus employee number, the threshold, apply to individual locations or company-wide? My understanding is that it's a company-wide threshold. So if you have 10 locations with 10 workers at each location, you're at the 100 employee limit. And Otto's nodding, so I take that to be a sign that that's correct. So those are the two questions we've had so far about vaccines.
Since we're addressing those questions, I'd add one other thing. When you get a copy of the standard, and if you want one, email me and I'll send it to you. You'll see on starting on page 6, remember, this is a proposed standard, and the OSHA is trying to decide whether to make it a permanent standard. And so there are a series of questions starting on page 6 under requests for comment, and they ask some fairly detailed questions about your workforce, how things work for you, and it may be worth completing those and responding to those questions because they're still, this is still evolving, and in a world where we do frequently asked questions instead of regulations, it could evolve sooner than later.
Thanks, Otto. Last question, if an employee won't vax or test for no reason at all, what are the employer's options at that point? I think you're looking at a separation. If they won't vax or test and they have no basis for an accommodation, that's what this whole mandate is all about. It's forcing people to get vaccinated, and the mandate puts people's jobs on the line to accomplish that objective. So I think every case needs to be vetted, individually. Don't take that as a blanket piece of advice, but that I think is going to be the end result. If you just have an employee who says, I'm not going to get vaccinated or tested and I've got no basis for it, I think you're going to separate the worker. Because if you don't, keep in mind, the penalties for not complying with this are very significant. OSHA doesn't have enough inspectors to be knocking on your doors. So we're talking about $14,000 per incident and then multiple times that for repeat incidents. So you don't want to be on the receiving end of a violation. It's very costly. So with that, the last topic we're going to cover involves an area that I think is rapidly emerging both as a risk factor for employers and as a source of concern about how to address, and that is LGBTQ rights in the workplace. We've included this topic in the presentation because of the volume of questions we have received from clients about it and the uncertainty about handling these issues as they occur. So having said that, Julia is now going to share with us what she knows about this very important and timely topic. Julia?
Thank you, John. I will try to do some speed lawyering here so we don't keep you all too late. This really came about in June of 2020 with a U.S. Supreme Court decision in which the U.S. Supreme Court stated that the protection under Title VII that prohibits discrimination or harassment based on sex included discrimination based on sexual orientation and gender identity. And this was really a landmark decision. The Supreme Court has kind of danced around this and talked about stereotyping and come really close, but it was never before had they made this type of clear declaration. However, given the timing, I'm told there was a pandemic ravaging the world, it was somewhat overshadowed, and that is part of why we wanted to bring it up now, is because this is very significant, and not only is it in effect, but it's been in effect for a year and a half. So the EEOC expects you to know this, but in my personal experience with clients, a lot of them simply are a little bit behind the curve on this issue because it has come somewhat quickly, particularly with respect to gender identity. So we want you to get out ahead of this and be able to identify these issues and know how to deal with them before you find yourself facing some sort of charge. So as with other types of discrimination under Title VII, sexual orientation and gender identity discrimination applies to every aspect of the employment relationship. And so this is true for all protected categories: hiring, firing, pay, promotions, job assignments, layoffs, training, fringe benefits, and all terms and conditions of employment. And if any of you have ever faced any sort of charge from virtually any of the agencies, you know that a term and condition of employment can be just about anything. I personally believe what type of coffee you have in the break room should be a term and condition of employment. I'm still working on that. We'll see. But so what are some examples where this might come up and where you may actually have a violation already if you're not particularly mindful on this? First, your benefit plans need to apply equally to same-sex couples and opposite-sex couples. Now, in Arizona, again, because of a U.S. Supreme Court decision, clearly same-sex marriage has been legal for the last few years. But to the extent that your benefit plans, let's say they apply to just significant others, things like that, you need to make sure that there is nothing in the language of those plans that would somehow exclude a same-sex couple or anyone else that is anything outside of the traditional male and female relationship. Most of your insurance companies are going to be on top of this, but certainly if you are self-insured or offer any additional benefits, make sure that those are not inadvertently discriminatory. Also, leave policies, and I mention this because while I do primarily labor and employment, I do just a few adoptions on the side. It's the warm, fuzzy part of my practice. And so this is an issue a lot of people don't necessarily understand. It can be time-consuming. Adoptions can take people out of the country if they're doing an international adoption. If it's a DCS adoption, there are going to be several court hearings and things like that. And then you may have, if you have an unmarried couple living together, you may only adopt if you're married. So you may have an employee whose significant other legally adopts a child, but that employee is also co-parenting that child. They have just not legally adopted. And so you're going to want to be prepared to, if you would ever allow a non-spouse time off to care for an adopted child or a new child, you need to do the same in this situation. So just make sure you're being sensitive to and mindful of those types of leaves. It's not always just a 12-week maternity or paternity leave. And finally, I get this question a lot in several of the categories of Title VII, and that is, okay, well, we are all for equality, but we've got this jerk client who's always telling us, don't you give me any X, at my work site or whatever it is. That is not acceptable. And I understand that that is difficult because that potentially could lose you that client. But you absolutely may not deny an individual, one of your employees, an opportunity or an assignment because of a real or perceived belief that your customers or a certain customer would prefer to work with individuals of a particular sexual orientation or gender identity. The only time I have given advice that may allow someone to sort of work with a client like this is if you can absolutely guarantee that if you were to not place this particular employee on this other client's account or something like that, if you can guarantee and you're very comfortable that you are still providing that employee with 100% the same opportunities for advancement, for learning, financially, then perhaps you can choose to do that and just say, okay, I'm going to choose to place employee A on this account and employee B on this account. But you really need to make certain that that individual is not suffering in any way as a result of that client's particular biases. Oh, sorry. Okay. I included this couple of slides because I feel like these terms have changed quite a bit recently, and this is one of those questions nobody wants to ask because they all want to pretend that they know what it means or they feel kind of badly if they don't know what they all mean. And the reality is some of these are relatively new, and so I want to make sure you understand what these terms mean so that when someone approaches you with an issue, like perhaps saying, my coworker is making fun of me because he just called me queer, you're going to have a better understanding of what type of a complaint this individual is making. And I'll actually mention that term queer. I use that on purpose here in a minute. So LGBTQ+, that is not the only term. Some people say LGBTQ, some say LGBTQ+, some add an I and an E. This one, I think, is pretty common and pretty inclusive. So that stands for lesbian, gay, bisexual, transgender, queer, and others. So the others, two of the more common other categories currently are perhaps a pansexual and two-spirit, which I will discuss shortly. But transgender, this is a term that we hear a lot now, but that a lot of people, if they don't have a personal experience with this or a friend or close family member, they may not fully understand the various stages of being transgendered. This is a term that's used to describe an individual whose sense of personal identification does not conform to his or her biological sex. So in a moment, I'm going to go through the terminology more, but we'll discuss the different stages of being transgendered and how you need to approach each of those. But first, when we're talking about that plus in the LGBTQ plus, pansexual is probably the most common that falls within the plus category. And that is someone that has sexual or romantic attraction toward people regardless of gender, okay? That is somewhat different from bisexual, which is sort of indicates definitely two genders. This pansexual typically also would incorporate things like transgendered individuals, that sort of thing. Two-spirit can actually incorporate a couple of different protected categories because this really originates in Native American, First Nations, and Indigenous cultures. And this has been around for quite some time in many of these cultures. And these are individuals that have both a male and a female spirit within them. There are strict rules and cultural norms associated with this within individual tribes. So with this, you're going to need to be mindful of the Native American rights as well as the sexual orientation rights. And then gender fluid is someone whose gender identity is not fixed but changes over time. Now that is going to be one where that you're going to have to really remain in open communication with that individual in order to abide by your obligations under the law. I want to mention quickly the term queer because that has taken on a different meaning over time. If you are not personally if you don't fall within the LGBTQ plus title or categories, it is typically considered a slur for you to use the word queer. Okay, it is a term that's sort of an umbrella term. It basically incorporates all of the terms we've been discussing, and it's considered, this is just a social norm, it's considered appropriate for someone that is LGBTQ plus to use that term, just as an umbrella term. But if you do not fall in that category, you should not be using that term. And if you find or get a complaint from someone that someone who is not LGBTQ plus is using that term in the workplace, you have a harassment complaint. Okay, and it needs to be treated as such. That is a sexual harassment complaint. Okay, with respect to transgender, the law doesn't only protect individuals who have gone through a physical transition, okay? You are considered transgendered the moment you acknowledge that you identify as a gender other than your biological sex. Okay, so the initial stage of this is a social transition. That's when you are coming out to your family or friends. You may begin using the pronouns that align with the gender you personally identify with. You might use a different name. You might begin dressing differently. Those individuals are every bit as protected as someone who has actually undergone some sort of physical transition or hormone therapy. So that is someone that's in social transition. Physical transition can also take many stages. And individuals, some of them will stop at social transition. Some will go all the way through to, multiple surgeries. There are many different, it's up to that individual's personal choice and personal feelings. So physical transition can involve taking hormone therapy, which can change some physical attributes, undergoing various levels of surgical procedures, and otherwise trying to change parts of the body to more closely align with the gender with which that individual identifies. Okay, so this is really just a little, I hope I'm not getting too basic for you, but this is just sort of a little background so that when you are faced with someone making a complaint or that has some concerns, or even you just hear, oh, this individual happens to be going through a physical transition, you'll understand that and understand that those individuals are protected under the law. So I will very quickly go through these because these are all examples I have heard before. So, okay, not okay. It's okay to accidentally refer to a coworker by a previous name, okay, or by the wrong pronouns. I have under that accidentally using the wrong pronouns. Okay, you're allowed to make mistakes. I call people the wrong name all the time, and it has nothing to do with their gender identity or anything like that. So it's okay. However, if you refuse to use a coworker's preferred name, or you are intentionally or repeatedly using the wrong pronouns, that is not okay. That is harassment, okay? If you force a transgender employee to use the restroom matching his or her biological sex, That is not allowed. And I particularly have a lot of parents who this surprises them, but I've got news for you. If you ask your children, this is the rule in their schools. Children use the bathroom for the gender with which they identify, almost universally. This is not a big deal to them. This is kind of an older generation problem. You know, this is an us problem. So this is actually quite common, that you need to permit all employees to use the restroom that matches their gender identity, or you can make all restrooms unisex. Now, one issue I always get is, well, okay, if this individual, you know, we have all these people that are going to get offended if this person uses the other restroom. So what we've done is we took the broom closet and we put a toilet in there and, you know, like a still life, and that is going to be their bathroom. No, that is not acceptable. That's essentially ostracizing that individual and saying, nope, you can't use the women's bathroom or the men's bathroom. You have to go use the broom closet bathroom. If you do have individuals that are very seriously offended by something like this, they are the individuals that need to use the broom closet bathroom, okay? People that are offended by this are not protected under the law. So if you get yourself in a situation where two employees can't deal with this, then it is the one who is being less tolerant that needs to be required to use the separate restroom.
Hey, Julia, really quick, should the third cells be flipped under okay and not okay? So forcing a transgender employee to use the restroom matching his or her biological sex is not okay. Permitting all employees.
Yes, sorry.
Yeah,
very good catch there, John. And I'm afraid I've probably used this slide before too. So John is correct. It is not okay to force someone to use a certain bathroom. You must let people use the bathroom that matches the gender with which they identify. Absolutely. Thank you. It is not okay to require employees to dress in accordance with their biological sex. Check your dress code. I'll bet it has something where it separates men and women. And when it says what is permissible, it'll say, you know, XYZ for men, you know, pants, polo shirt, whatever. For women, it will say skirt, dress, this and that. At this point, I would recommend that you just have a general, this is clothing that is acceptable to us, because you may have someone whose biological sex is male who is going to wear a skirt or a dress. And you may have someone whose biological sex is female that is going to wear more stereotypically male clothing. So make sure that you don't have sort of a gendered dress code. And then finally, I feel sort of bad, this is my final slide, it's kind of sad, but, well, it's very sad. But I always think that people will understand and remember the law better if they truly understand why the law is the way that it is. Okay, and despite anyone's personal beliefs, people can have their own personal beliefs, and I respect that, but statistically speaking, and the UCLA School of Law did a huge study on this, transgender adults have a significantly higher suicide rate than the overall US population, and they went through different reasons as to why that was, and experiencing discrimination or violence in the workplace was identified as one of the primary risk factors leading to increased suicidal thoughts and attempts. So this is a very real situation with very real world consequences for these individuals. So not only is this the law, but it's important just as a human being to you know, protect those, protect our coworkers and those who work for us. And that's all.
Thank you, Julia. One major takeaway from all that is that for those of you, and I'm sure a lot of you, or perhaps all of you have dealt with this, have dealt with accommodating protected characteristics under Title VII. You just need to put this category into that group of protected characteristics now. You handle them the same way and deal with them similarly, but you just need to know that although Title VII itself, the statute, only talks about sex, the Supreme Court has now expanded this through decisional law to include all of the various additional categories that Julia has described. So it's a new area in that respect, but the way in which you should address it should largely be the same, okay? That's really the big takeaway from it. So we are a little bit over. I want to thank everybody for their patience. I can see that not many people left, so I hope that means it was interesting and informative. Once again, if you have questions that we weren't able to answer, please follow up with us. We're happy to do that for you, as always. And again, I always say that at the end of these webinars, if you have suggestions about what you would like to hear about the next time around, which likely will be in the spring, we're going to do another one of these, please let us know. You can email any one of us or give us a call and talk to us about it. And we will see what we can do about putting the topic you are interested in on the agenda. So it is 12:12. I want to thank you all again for participating. It was great, even though we're still not meeting in person, to host this for you. And stay safe, and we'll be talking to you soon. Thank you, everybody. We appreciate you. Take care now.
Thank you.